Welcome. Thanks so much for joining us today. My name is Kara Bloomberg, and I'm the Chief Operating Officer of Landrum HR. For those of you that aren't familiar with Landrum HR, we're a 50-year-old professional services firm. We focus on, sorry, sorry about that. We focus on providing end-to-end talent solutions for our clients. We have service lines that include worksite management, a customized labor solution for companies that use large numbers of temporary workers. We also provide PEO services that include payroll, benefits, workers' compensation, and HR. In 2019, we joined with HRQ. HRQ provides 3 integrated services: enterprise-wide human capital consulting, providing interim HR talent, and conducting searches for HR professionals. Our consulting team brings a depth of experience in workforce planning and analytics, talent management, and talent strategy projects, org design, and HR transformation needs. A few housekeeping items before we get started today. A recording of this webinar will be sent to everyone that registered. We appreciate if you'd like to enter some questions into our question panel. We'll try to get to some of those at the end of the webinar. There's also a quick survey that's going to pop up at the end today, and we'd appreciate your feedback. And we also have a handout that's provided that Becki will reference later in the presentation. So I'll get started today introducing our speaker, Becki Haines. Becki has over 25 years of human resources experience, and she holds a business degree with a concentration in HR. She is certified as a professional in human resources by the HR Certification Institute and as a certified professional through SHRM. She also holds her SHRM People Analytics Specialty Credential. Becki's a 10-year employee of Landrum HR, and she's worked with staffing, PEO, and consulting all within the company. She currently holds the position of Managing Consultant for HRQ, our national human capital consulting firm. Prior to joining Landrum HR, Becki was the head of human resources for the largest behavioral healthcare system in Alabama, where she led the HR team in the proper execution of the recruitment, employee benefits, compensation, workers' compensation, and safety disciplines for 1,000 staff. Becki is passionate about helping organizations best manage their greatest resource, their people. Becki's a teacher at heart, and she focuses on helping business leaders understand the why behind the what, so they can move forward with confidence in their decisions. So Becki, here we are. Newsfeed's been blowing up with OSHA ETS, better known as the vaccine mandate. Before we get started, I'd love to take a quick poll of our audience. And I know we have people from across the country, all different size employers. And I want to get an opportunity for us to just gauge everyone's comfort level with their knowledge on the subject as it stands right now. So if we can launch the poll, and if we can ask participants to chime in here. The poll question is, how familiar are you with the specifics of the OSHA ETS? A, very familiar. B, somewhat familiar. C, not familiar. And we'll get started on the poll. And we're collecting our responses now, and just give everyone a few more seconds. Appreciate everyone participating today. And I think we'll just go ahead and close that out now. Thanks so much. So sharing the poll results here, it looks like the majority of our participants, 77%, say they're somewhat familiar, Becki, with, so probably been reading in the news, reading up, preparing. So happy that everyone's here today participating to learn more, figure out where we stand. It's been changing on a daily basis. So Becki, I know it feels like we've been watching a ping pong match for the last week and a half. We've been preparing for this webinar, and every day it's something different. So help us fill in the gaps, especially for those of us that don't eat, sleep, and breathe employment matters on a daily basis. Becki, I think you might be on mute.
Thank you, Kara. I appreciate that introduction. And yes, it does feel like a ping pong match. I looked at my calendar yesterday and thought, surely it's been 2 months since that ETS was originally released, with as much reading as I've had to do on it and how it has been changing on a daily basis. So I appreciate everyone joining us today. I would like to start by making sure that everybody understands the terminology. We're hearing a lot about the vaccine mandate in the news and your social feed, and really that's kind of a slang term for the COVID-19 vaccination and testing ETS. So those are one and the same. So when you hear me refer today to the ETS, please know that I am referencing the vaccine mandate. So let's take a step back for a minute and make sure that everyone knows a bit about what an ETS is. ETS stands for Emergency Temporary Standard. The Occupational Health and Safety Administration, or OSHA, is authorized to set these emergency temporary standards only when workers are in grave danger and an ETS is needed to protect them. They do take effect immediately. So the minute that they are released to the Federal Register, they take effect immediately, and they're only in effect for a maximum of 6 months. They could be less than that if a permanent standard is approved and adopted, whichever is sooner, but it'll never go past 6 months. Now, when the ETS is published, it's published in the Federal Register, and that's where it will also serve as a proposed permanent standard. Basically, it'll start going through that process for adopting a permanent standard that it would have had to go through anyway had there not been an emergency situation at play. So many of you are just now getting familiar with what an ETS is because we're hearing so much about it this year. But I want to assure you that you really weren't supposed to know about it, because honestly, before 2021, the last time we've been dealing with an ETS, the last ETS OSHA actually administered was in the early 80s. It was when asbestos was a real threat to the work environment. So unless you were in business 40 years ago, prior to 2021, you really would not have had a need to know about an ETS. Now, the validity of ETSs are often challenged in court, which is actually what we're experiencing right now. Historically, in fact, OSHA has only used the ETS 9 other times before this year. 6 of those were challenged in court, and only one of those standards actually stood up to the scrutiny. So you can see it doesn't have a lot of staying power historically. Now, the COVID-19 vaccination and testing ETS was released on Thursday, about a week and a half ago, November 4th. And then it was recorded in the Federal Register the following day, the 5th. And in a nutshell, the ETS requires employers with 100 or more employees to mandate their employees either be vaccinated or tested weekly for COVID-19. Now, this is one piece of a 6-pronged comprehensive national strategy that the Biden administration put together in an effort to combat the COVID-19 virus, to save lives, and to protect the economy, hopefully, from further lockdowns. But as you guys all know by now, it was immediately challenged in court. Lawsuits were actually filed in the U.S. Court of Appeals for the 5th, 6th, 7th, 8th, 11th, and D.C. circuits. So to help you put that in better perspective, that represents over 26 states that took part in a lawsuit. So that's over half of our union. So quite a force there. So to say that they were sitting on ready would be an understatement. Most all of those lawsuits came out the day that it was written in the Federal Register. So, you know, as business people, I think it's really important that we understand what the arguments are. The arguments against this legality of the ETS, because it's going to set precedent one way or the other. Whether you support it or not, it will certainly set a precedent. So we're going to go through some of those now so you understand why is this even being challenged legally. And the first argument is that this ETS is just beyond the scope of OSHA's authority. That this constitutes a major rule that requires specific legislative authority beyond what OSHA was ever given by Congress when the OSHA Act was enacted. You know, the absence of such authority would then violate the non-delegation doctrine. And we actually have some recent federal court decisions that support this argument. You may recall the CDC's attempt to exercise authority over landlord-tenant relationships when they tried to make that eviction moratorium. Well, that was overturned for that very same reason. And there's also case law overturning the ban on the cruise industry due to the administration's concerns over the pandemic. Another argument is that the ETS violates the Commerce Clause because there's no specific relationship to commerce that would allow the federal government to intervene, especially since public health and safety are policy powers granted in the 10th Amendment, and it's granted to the states. So essentially what they're saying here is a decision not to receive the mandated vaccination is not a federally regulated commercial activity because it's between the unvaccinated employee and either the employer or the vaccine provider, with likely no commerce or exchange of goods for money in order for Congress or OSHA to even get involved to regulate it. Now, another argument is that there is no grave danger unique to workers. As you remember, that was one of the bases for why an ETS would be granted. So basically, they're arguing that, we're nearly 2 years into the pandemic. The CDC says we have 70% of people that have already received at least one dose of the vaccine, and there's a declining infection rate. In addition, COVID-19 is a communicable disease threatening the public health at large. It's not a hazard unique to a workplace or all workplaces, and therefore their argument is that it's beyond OSHA's ability to regulate. And then petitioners also argue that OSHA has the science wrong, that the ETS seems to completely discount natural immunity. They also note that the ETS erroneously defines grave danger as the lack of vaccination, where they believe it should be the lack of immunity. And then finally, the Fifth Circuit in particular has argued that irreparable harm will come to businesses as the administrative and financial burden required by this ETS is really high. Now, the Seventh Circuit took it a bit further and stated that the businesses covered by this ETS will lose their employees to smaller corporations that aren't covered. And, obviously we're in the middle of a severe labor shortage. I know all of you have experienced that in one way or another. And the argument here is that it could cripple business. So we had all these lawsuits come out literally the day that it was posted in the Federal Register that Friday. And by the following day, Saturday, November the 6th, a 3-judge panel of the U.S. Court of Appeals for the Fifth Circuit granted a nationwide stay of the ETS. Now, the Biden administration was given until close of business that following Monday to respond to the action, and they did. And they very clearly asked the court to lift the stay. They warned that delaying implementation would likely cost dozens or even hundreds of lives per day. The White House went as far as to tell businesses to press ahead, keep implementing the requirements as the legal drama unfolds and plays out in the court. So that was Monday. And then by late Friday, this past Friday, the 12th, the Fifth Circuit issued a 22-page ruling reaffirming their decision on the stay. And they were pretty forceful in their language. They called the vaccine mandate fatally flawed, staggeringly overbroad, and their opinion really took apart the OSHA mandate in every which way, on constitutional, statutory, and procedural grounds. They specifically stated that the petitioners were very likely to succeed in their claim of an unlawful overreach, and then they barred the government from moving forward with the ETS. Now, one of those 3 judges was Judge Engelhardt. He was extremely outspoken, and one of the things he said, and I'll quote it for you here, he said, "The principles at stake when it comes to the mandate are not reducible to dollars and cents. The public interest is also served by maintaining our constitutional structure and maintaining the liberty of individuals to make intensely personal decisions according to their own convictions, even or perhaps particularly when those decisions frustrate government officials." So we can tell it is getting very heated between these two. The Biden administration has come back and said, hey, we're still going to defend this mandate. And so the question for us today is, what happens next? Well, even though the stay came out of the Fifth Circuit, with so many different lawsuits filed in various federal judicial circuits, by federal statutes, the cases will be consolidated and they have to be transferred to one circuit. And that one circuit will be chosen by a lottery. The judicial panel on multi-district litigation will be the entity that will randomly choose that circuit. The members of that panel are all going to be chosen by Chief Justice Roberts. And actually, it's supposed to happen today. So who knows, Kara, we might have some breaking news in the middle of our webinar to determine which circuit is going to be able to hear this consolidated case. The only real threat that I think this continues to have for businesses is the possibility that this case is transferred into a judicial circuit that disagrees with the stay. If that happens, the stay could be lifted as early as the end of next week. So keep your eyes and ears peeled on that. Of course, we here at Landrum HR will immediately notify you as our clients as that happens. So we'll see how that plays out. So hopefully that brings us up to date on kind of where we're at now. I know it's been really confusing. It has been a lot of volleying back and forth. Y'all have full-time jobs. You certainly don't need to be spending hours researching the ETS. That's really what we're here for. But the reality is this will most likely end up in the Supreme Court. And currently, the Supreme Court has a conservative majority. And so it will almost certainly lose if the challenge goes that far. All that being said, as business owners and leaders, we're now left in a holding pattern. While the stay is in force, obviously there's no compliance requirements for it. But when or if that stay is lifted, there is no guarantee that the due dates for compliance are going to be pushed back to from what their original due dates were. So all that being said, the time to prepare is now. So today what I'd like to do is go into some of the more common questions that we're getting. Certainly we're not going to do a super deep dive today as the stay is still in full force, but you do have our promise that should the stay be lifted, we'll immediately schedule another webinar and dive a whole lot deeper on all of your questions. So Kara, I know that we've had a lot of questions coming in over the last week and a half. Let's go over some of the more common ones.
Yeah, thanks, Becky. We've definitely been collecting questions from our clients for the last few weeks, and we just felt like that's a good place for us to start here on the most common things that we're hearing. I know our legal team, our HR business partners have been incredibly busy trying to field some questions with our clients and thought it would be best for it to carry over there. So let's start with my business is located in a state with an OSHA approved state plan. Will this ETS apply to us?
Well, the short answer on that is yes. So states with OSHA approved state plans are required to adopt the ETS, or they can have a standard that's at least as effective as the ETS. Now, the ETS gave them 30 days to comply, and OSHA was pretty straightforward on what they thought about states who might not comply or states that they maybe wouldn't hear from. And so they said in the ETS, if that's going to happen, we're putting you on notice that we could begin to withdraw your approval for a state plan, and we would resume federal jurisdiction over your state. So that's kind of a big deal. There's some teeth there to that. And so states have been put on notice that should this ETS move forward, they need to comply with a plan within 30 days.
Thanks, Becky. The next question, are any employers of 100 or more employees not covered by the ETS?
Yes, actually there are two exceptions for employers. One is if you're a federal contractor or a subcontractor and you're covered by the Safer Federal Workforce Task Force COVID-19 Workplace Safety Guidance. That's a mouthful, isn't it? So you've already had, if you fall into that category, you already have much stricter standards than this ETS is going to provide for. The other employer that would be exempt from this would be those who are subject to the healthcare ETS that came out earlier this year.
And then if you can, walk us through exactly how the 100 employee threshold is calculated.
Sure. Well, it is calculated by single corporate entity, regardless of location. So it's not by work site. And this includes all of your W-2 employees. So it doesn't matter if they work at home, they work outside, if they work in a different location. It is all of your employees. So this is not an FTE requirement like sometimes the government asks for. It's not a full-time equivalent. This is every single employee. It's an employee count. So whether it's part-time or full-time, they're all counted. The only workers that are not counted to make up the 100 employee threshold would be workers that you get from a staffing agency or contract workers that you pay with a 1099.
So now we'll go a little bit deeper, and we have a lot of clients that fall into this next category. If an organization has many different entities, they have separate FEINs, and separately, none of them have over 100, but collectively they do. What are the rules?
Oh, this one's a tough one because I have to give you the terrible answer that it depends, right? So at this point, there's nothing in the ETS that states that common ownership across entities should be viewed as a singular employer for the purposes of meeting that 100 employee threshold. However, there is a caveat in the ETS that says that if those entities are actively engaged in worksite safety activities together, then they do have to be combined for the purposes of this threshold. So for instance, if you had one safety manager that went from entity to entity and put on the same workplace safety program, then you would have to combine all of those entities to see if you met the threshold.
Oh, I'm sure a lot more questions to come on that. That's going to be sticky.
Yeah, for sure.
Let's talk about the employees then. So if a company has over 100 employees, as you've just defined for us, are all of their employees subject to the mandate?
Actually, no. So you can be a covered employer, and that doesn't mean that all of your employees are going to be covered. There are 3 specific areas that the ETS carved out that they said these particular employees do not have to be covered. One are those employees who work in a place where there just are no people. So they might go and work in your facility, but they're not around customers, patients, clients, or coworkers. They're just working by themselves. The second area is those that work from home. So as you may recall, OSHA does not define an employee's residence as a workplace. So if they work from home, they do not have to submit to this ETS. Now, with both of those, I will say that you have to be careful that if you're asking them to come into the office, maybe for a monthly meeting or maybe for a training, then when you do that, you need to make sure that they're providing you a negative COVID test that was taken within 7 days prior to their visit. Now, the third area that they've carved out, the third employee group they've carved out, is those employees that work exclusively outdoors. And that does mean exclusively. So if they work 1 day in the office and 4 days outside, it isn't going to count. So they have to work exclusively outdoors. They also made the comment that they can't routinely occupy vehicles with other employees. So if your business is such that you ask them to come to maybe the main office in the morning and 2 or 3 coworkers get into a truck together and they go out to a work site where they will be working outdoors, they still would have to comply with the ETS because they're routinely in that vehicle with one another. Now, they have said that for those that are working outside, if they need to come in for incidental periods of time to use the facilities, to have a quick face-to-face meeting, then that is not going to keep them from this exemption as long as it's de minimis time.
Wow, so a lot hinging on, I know many of our clients, their return to work strategies also around this and remote work. So a lot more to come there, I'm sure. And so we'll jump into some of the definitions also about what's considered fully vaccinated for an employee?
So for the ETS, they have defined fully vaccinated as being 2 weeks after the second dose if it's a 2-dose vaccination, or 2 weeks after a single dose for a 1-dose vaccination. Interestingly enough, under the definition for fully vaccinated, they don't talk about boosters at all. So booster shots have not been brought into this definition.
And then let's talk about payment of the vaccinations. I know that's a lot of the question. Who's going to pay for the vaccinations?
Yeah, I think that's a really hot topic, right? So for those employees that you have that are going to get the vaccine, the company does have to pay for that vaccination. And they also have to pay for 4 hours of leave for each primary series dose. And that includes travel time. So 4 hours surrounding that period of time. Now, keep in mind that they've also said that that 4 hours can't be taken away from any accrued time the employee has earned. So you can't dip into their PTO bank, you can't dip into their sick leave in order to accommodate that 4 hours. So if you are a Landrum HR client and you run your payroll through us, please know that we've already taken steps to make sure that there'll be a specific pay code for you to utilize there should this ETS stay be lifted, and you'll be able to use that to better track that time. Now, as far as time that they might need to recover from side effects from the vaccination, the ETS does say that you are mandated to give them a reasonable amount of paid sick leave for that as well. And they further define reasonable amount of time as being 2 days. And that time can come from their accrued leave bank. So a little different in how you can dip into accrued leave on each one of those, but just know that you will need to provide that time.
And what about any employees that have had COVID? Are they exempt from the mandate?
Well, no, they're not. There are no exceptions in the ETS for natural immunity, which, if you recall, was one of the arguments in the lawsuit that the natural immunity was not considered.
Okay, and then let's talk a little bit more about unvaccinated employees. So how often do unvaccinated employees have to test?
So covered employers must ensure that each employee who's not fully vaccinated and then reports at least once every 7 days to a workplace where other individuals are present are tested for COVID at least once every 7 days, and they have to provide documentation of the most recent COVID-19 test result to their employer no later than the 7th day following the date on which they last provided the test result. So keep in mind that you're going to have some employees that are going to go on vacation, who might opt to work from home for a period of time, or otherwise not be in the office. During those times, there's no requirement for them to test.
Yeah, that's really going to get complicated with everyone's flexible work schedules. So many people now having a lot more flexibility in when they can come in.
Yeah, it's from a tracking perspective going to be difficult.
Yeah. So what about the requirement for the testing cost? Is the employer required to pay for the testing if the employees choose to be tested instead of vaccinated?
No, actually, the employer is not required to do so by OSHA standards in this ETS. And actually, this is the first time that OSHA, to my knowledge, has ever allowed for employees to pay for anything. It's definitely their stick of sorts to try to steer everyone in the direction of vaccination. But I do want you to keep in mind that there are other elements outside of OSHA that may require payment. So, for instance, if you have an employee that, due to a disability, is unable to take the vaccine, and they, require an accommodation, well, part of that accommodation is going to be you paying for their testing. There's also state and local laws that may mandate employer-required testing that is solely paid by the employer. So, for instance, I know state of Kentucky is one of those. where if you're going to have an employer-required test, you have to pay for it as an employer. So you're going to want to make sure you're getting really sound HR consultation with all of this, because there's lots of different legal requirements outside of OSHA that may come into effect here. And then for those of you that have union representation amongst your employee group, make sure you're checking that collective bargaining agreement, because the collective bargaining agreement may very well require that you foot the bill for that. So a couple of things to remember here. Again, make sure you're getting very sound consultation from your HR business partner. You want every I dotted and T crossed. There's lots of different elements to look at here. And then the other thing is, you can always be more generous. You can always be more generous than the law allows for if it's in your budget and you can cover the testing yourself. There's nothing wrong with that.
So outside of covering the cost for testing and the exceptions that you discussed, there's also going to be some reasonable accommodations, right, for medical, religious, or other reasons that may affect employees. Can you go through that with us?
Yeah, so OSHA defers to the EEOC guidance on this, and they also indicate that unvaccinated employees can seek accommodations for the testing alternative as well. So it's good to keep in mind as employers that this is not circumventing employees' rights under either the Americans with Disabilities Act or ADA. It's not circumventing their rights under Title VII of the Civil Rights Act. So yet another reason why you need really good HR consultation, because you're going to have these accommodation requests come in, and you're going to want to make sure that you're handling them legally, that you're handling them fairly, and that you can easily defend the decision that was ultimately made to a third party in the future should you need to.
And Becky, I'm sure you would say the importance of consistency in that decision-making process.
Yeah. Absolutely.
So what about maintaining the roster? So maintaining all the records, all of the things that employers are going to have to maintain. So is that all fall on the responsibility of the employer?
Yes, it's absolutely the employer's responsibility to not only maintain a roster, but to have acceptable evidence of an employee's vaccination or their COVID test results. So you actually have to have the evidence as well to back that roster up. The other element that I can remember that the ETS spoke to is that you as an employer have to keep a computation of the aggregate number of vaccinations for your employees versus the total number of employees at your work site. So what the ETS says is that, hey, if you have an employee that comes to you and says, I want to see what the numbers look like at my work site, you need to be able to give them that aggregate number of vaccinated employees versus the total number of employees that work there whenever they ask. So we're going to have to be prepared for that.
And what about training and policy requirements for the employers?
Well, yes, there's absolutely a component there in the ETS for that as well. You know, employers who are covered are required to publish a written policy. The policy has to either mandate vaccines or provide the vaccine testing alternative. They're also required to provide information to employees about the safety, efficacy, and the benefits of vaccination as well.
So Becky, I want to go back on something that kind of from earlier in the presentation when you mentioned the mandate, and I think there's some confusion. We had some questions come in, so I want to reiterate this about how they consider covered employers. So that number is 100, right? But then there's also employees that are within that group that are going to be exempt, and so the people that work remote, for example, will count in the 100 employee requirements and make the employer subject to the mandate. However, those employees may be exempt if they're totally remote, as you described earlier. Did I state that correctly? Just to make sure that because there's a couple of questions on that.
Sure. Yes, you did. So essentially, just let's break it down very simplistically. If you are a 100-man group, and 50 of your employees are working from home, you are a covered employer because all of your employees have to be counted towards that 100 employee threshold. However, as a covered employer, not all of your employees will be covered. Those that are working exclusively from home, those 50, will not have to be subject to the ETS requirements, whereas the 50 that are coming into your facility will have to be.
Great. Thanks for clearing that. I think there's a lot of confusion around those numbers. So hopefully that helped with everybody, and we'll please submit some more questions if there's anything specific you'd like to ask. So, okay, one of our last questions, when all of this is going to take effect?
Well, that is the million-dollar question, isn't it? I mean, the reality is this may not take effect at all. Or if the stay is lifted, we may have very little time to comply. The original ETS stated that all the requirements except for the testing portion had to be taken care of in the first 30 days. So that put us on, I believe, at December 5th, which was a Sunday. The testing portion had to be implemented within 60 days, which put us on the 4th of January. So really, there's still somewhat of an unknown here, right? We don't even know exactly what we're dealing with. We're still in a little bit of a holding pattern. So that's why I really encourage all of the employers here on this call today to have a plan in place. You need to be sitting on ready just in case compliance is necessary.
Yeah, great advice, Becki. And I think that's really important is there's so many question marks today, but you don't want to be left if that date doesn't move and that line in the sand with the original date of compliance, December 5th, doesn't move and it happens to be here. We don't want anyone that's participating on this call to be unprepared. So definitely going through the process and going through the scenarios are so critical. So Becki, I'm gonna test you here because we have a lot of participants on the webinar, and I want to take a poll of really taking a look at what our participants feel like they know now. So how did we do? How familiar are you with the specifics after hearing today's presentation? And that would be very, somewhat, not familiar. We'll give a few minutes, and then definitely as we close out and we take any more questions, we'll try to get back to those and some follow-up. We are certainly prepared to do a follow-up webinar. Becki, I can't thank you enough, the HR team, our legal team. I know it has been just night and day, and every day's looked different as far as what this presentation was going to look like and the information that we wanted to get out. So really appreciate everyone's effort. I'm going to close out the poll now and share it out. So, hey, 62% very familiar, Becki. Awesome. You did
very
you did
good.
A great
That's
job.
what I like
Yeah.
to hear.
And we've got a long way to go, but just like with everything that's happened with COVID, with all of the legislation that's come out, we just want to be here for our clients, want to deliver information as we know it today. So we always say that, hey, this is what we know right now. We may be back tomorrow or next week and talking about what's new. But if you're one of our clients that you have an employee population that could be affected by this, you should have already had a one-on-one meeting scheduled with your HR business partner. And if not, we want to make sure that that happens. And at this point, it still appears that OSHA is taking public opinion on a permanent rule. So we want to encourage people to still reach out and make your voice heard. Becki, I was so surprised when you shared that with me yesterday that they're still taking public opinion.
I know, Kara. I actually went on because I didn't really think that would be the case. I went on myself to test it, and they are still taking public opinion. But again, this is a battle. I mean, I think we've seen some very strong wording from both sides, and they're both in it to win it.
So we have a Landrum HR resource page, and it's on our website for COVID and all things COVID-19. There's also a government link for the opinions that's on the page at landrumhr.com. So please visit our website. You can find a lot of good information there, and also that link out to the opinion page. You'll find a copy of a sample policy, and Becki, we included that also in the handout pane here of our presentation. OSHA's frequently asked questions, OSHA's fact sheet, among other things on the page, so please visit. And again, should this be lifted, we'll schedule a follow-up webinar as quickly as we can and do a much deeper dive into all of the requirements needed for your businesses to stay in compliance. Becki, thank you so much. Appreciate you and the team, all the effort you've done for this. and we'll be back, I'm sure.
Well, we're ready. We've done about 3 different webinars in preparation for this, and we are sitting on go. So certainly, again, let me reiterate, if you have questions, reach out to your HR business partner. That's what we're here for. We want you to sleep easier at night, knowing that you have the facts, and we want you to move forward with confidence.
All right, thanks for everyone for attending today. Hope you have a great day.